Thank you very much. It's indeed a great pleasure and a great honor for me to be invited to speak to you, and I'm really happy to see so many young women here who are studying tickets already, who are studying law and aspiring to be lawyers. I'm grateful to the principal and to the management of this fine institution for inviting me. And I'm a little overwhelmed by the kind words said to me, said about me by Father Venmanath. I think he went a little overboard in his. You see, I see myself as an ordinary, normal person who has, and this is something that I want you all to imbibe as well, who has tried to see what is happening in our society, in our country, and have tried to understand sort of a whole range of major issues that are before us. So, in that journey of trying to understand what is happening in our society and in our country, when I come across some injustice that I see, or something wrong that I feel is happening, or some wrong policies that are being followed, I try and raise my voice against that. I try and raise my voice, if possible, in the courts also, and to the extent that I can, outside the courts also. And that is what, see, a lawyer is not merely the agent of some client who comes to you. A lawyer is considered to be a civilized warrior for justice. So you are all going to be civilized warriors for justice. And you must never forget that you are not merely an agent of your client. And I have always adopted this practice, though it's not a practice which most lawyers adopt, that I do not take up a case of a person who I feel is not morally on the right side. It's only when I feel that this person is justified in whatever he has done, only then I take up his case. Now, of course, what is justified or not justified may be a subjective perception, but I have always been of the view that I do not want to lend my voice or whatever influence I have within the court or outside the court to advocate the cause of somebody that I feel is not morally in the right. I know that most lawyers are told, do not judge your client. That is for the judge to decide. You have to take up the case of anybody who comes to you and plead his case or advocate his case in the best possible way. I know that that is the advice that is normally given to lawyers. I just wanted to tell you I am not sure as to what is the right advice to follow, but I am telling you what I follow. The other thing that a lawyer should, before I go into this issue of environment, you see, if you ask this question, how many people are being able to get justice through this judicial system that we have in this country today? The honest answer to that would be very few, not more than few, 3, 4, 5%. And the reason for that is that the vast majority of the people who have suffered some injustice are unable to approach the courts at all because they cannot afford the fees of any lawyer. Therefore, they are not able to access the system at all. Even if they have been falsely charged by the police for some offense, they are unable to defend themselves, effectively defend themselves. They are unable to even secure bail for themselves, and therefore the vast majority of people who are today in jails are not convicts. They are just under trials or under investigation, who have merely been accused of a crime, and sometimes they stay in jail for years altogether. It is the job of, in my view, it is a job of any lawyer to try and help these people in whatever way one can. One can do it through public interest litigation. Also, the Supreme Court has taken up this issue in several cases and said that those under trials who have undergone more than half of the maximum imprisonment that can be imposed on them for the alleged crime, they have to be released forthwith. You can also take it up individually if you can. Of course, it's difficult because these people are all languishing in jails. But I'm just giving you this example that today, vast majority of the people can't access the judicial system. Those who can access it, who have the money to pay a lawyer, are either suffering delays in the court because their cases don't come to be decided. And even when their cases come to be decided, they are often wrongly decided because of the incompetence of the lawyer, incompetence of the judge, or sometimes even corruption on the part of the judge. And the result is that very, very few people are able to get justice in a time-bound manner in our judicial system. Now, as lawyers, as any public-spirited citizen, especially a lawyer, we should feel a duty to try and help to fix the system, to reform the system, so that people can effectively get justice through the system. Our job is not to just use this profession to make money. Our job is to ensure that the system of justice works and people get justice. Now, how do we fix this system? As I said, one problem is that most people can't access lawyers, can't access the courts because they can't pay lawyers. The solution to that was found to some extent in this Gram Nyayalaya Act, which came in 2010, which provides for a simplified system of courts called Gram Nyayalayas, which would be set up at the sub-tehsil level, at the ward level, and which would also travel to the villages. These courts are not required to rigidly follow the code of civil procedure or the code of criminal procedure. They can adopt any procedure which is consistent with the principles of natural justice. Now, unfortunately, even 14 years from the act, very few Gram Nyayalayas have been set up, and very, very few are functional. Today, we should have had more than 5,000 Gram Nyayalayas across the country. But the fact is that we have less than 250. Not even 5% of the Gram Nyayalayas in the country are functional. That to some extent would have solved the problem of access, because at least in these Gram Nyayalayas for ordinary cases, people would have had access without even the help of lawyers, because these were simplified courts, not rigidly following. One of the reasons why people need lawyers is because of the complex nature of the procedure. CPC, CRPC is so complicated that lay people cannot negotiate this procedure. There is no reason for these very complicated procedures especially in these, or to decide these ordinary cases. When I was in the US, there used to be a program called People's Court. I don't know, maybe it is still running. So some television channel had got a retired judge of California to, to preside as a judge to decide actual cases which had been taken to court but which were now withdrawn and agreed by the parties to be decided by this retired judge. Now he used to call both parties with their documents and their witnesses, and he would ask the plaintiff, okay, what is your grievance? Then he would ask the defendant, okay, what do you have to say? And if he felt that there was any dispute of fact, he would ask the plaintiff, do you have any document to or any witness to prove this fact? He would ask the defendant what he has to say. He would allow the defendant to even cross-examine the plaintiff or his witness, etc., then and there. And in less than half an hour, he used to hear the whole case and decide the whole case. So I saw that program maybe 20-25 times. It used to be a 1.5 hour program in which at least 2-3 cases used to be heard and decided. And I thought that perfect justice had been done to all those cases. My father also saw it, and he also felt that this, yes, perfect justice has been done in these cases. There is no reason why ordinary cases cannot be decided in this manner. Of course, that judge was a very intelligent judge. You can't find too many such people. But you see, about a judge, today we have this problem that we do not have enough courts. The law commissions have been saying this repeatedly, that we need many more courts, etc. And that is why we are faced with this delays and pendency of cases, etc. The judiciary, on the other hand, I have taken several such cases to court where 100 vacancies are advertised in the lower judicial service or in the higher judicial service, that means at the level of civil judge or at the level of district judge, and only 10 people are selected, and 90 of the seats remain vacant. Today in the lower judiciary, there are 40%, more than 40% vacancies even among the existing posts. In the high courts, there are 30% vacancies. Supreme Court, there aren't any vacancies, but in the High Court, there are 30% vacancies. In the lower courts, there are 40% vacancies. And when I took these cases, and I said that, look, how can it be that 10,000 people apply, 1,000 people are shortlisted, meaning they qualify for the main exam. Among them, there are many who are toppers of their law schools, many who have even qualified for other judicial services in other states, and yet you have found them unfit. You have selected only 10 out of 100 people. How can it be? Obviously, there is some problem with your system of selection. To which the judges said, all these people had been failed in the written exam or in the interview, etc. The judges said, no, you don't understand. We don't find enough qualified people, enough worthy people to be appointed judges. Now the question is, what kind of person do you need to be appointed a judge? In my view, the main qualities that you need in a judge are, number one, he should have reasonable intelligence. Number two, he should have sound common sense. Number three, he should have a sense of equity and justice. And so far as legal knowledge is concerned, all that can be provided to him in 1 year in a good judicial training academy. In 1 year. So you select people, if you select people who have reasonably good intelligence, sound common sense, and a sense of equity and fairness, and then you give them training for 1 year, they will become, most of them will become reasonably good judges, reasonably good competent judges, at least for these Gram Nyayalayas, etc. Now, is there any shortage of such people in this country who have reasonable intelligence, sound common sense, and a sense of fairness and equity? There is no shortage. There is no reason why you cannot select more judges. Obviously, there is a problem with the system of selection. So, we need to set up these Gram Nyayalayas to provide access. We need to have more judges to speed up the process of disposal, etc. And we need to have competent and honest judges. Now, as I said, you can select competent judges if you have a proper examination to judge intelligence, common sense, and sense of fairness and equity. You can design such a test, kind of an aptitude test, which will test all these things. So there is no reason why you can't select good judges. The whole system of selection has somehow got, there are very, very serious problems in our system of selection. And then you need honesty. So you need to have a proper system of accountability for judges who become corrupt, etc. You need to have some institution which can, to whom complaints can be made and who can take action against these judges. So it is not that there are no solutions to the problem of judicial collapse as we are seeing today. There are solutions, but the problem is that neither the government nor, unfortunately, the sitting judiciary is interested in implementing these solutions. So therefore, how are these solutions going to be implemented? There has to be a people's movement. Just as there was a people's movement on the Lokpal issue against corruption, similarly, there needs to be a people's movement for judicial reforms. The judiciary is as important to the people as, or more important in fact, than the issue of corruption. And in that movement, lawyers who really understand the system from within have to play a major role. And that is why I am saying that quite apart from keeping your eyes and ears open to what is happening in society, you need to also participate in whatever way you can to bring about these judicial reforms that are required. Now I come to this main subject of environment. So, you see, the problem with all of us know and understand that environment is a serious issue. It has become a serious problem. Because we have carried on development without having regard to environmental impacts of that development. What we are seeing is increasing air pollution, increasing water pollution, depletion of groundwater, depletion of mineral resources, rapid depletion of mineral resources. We are seeing global warming. All kinds of impacts are being felt which were not bothered about by those who decided to do this kind of development. For a long time, there was not even a law which required the government or the authorities to examine environmental impact of projects before they were allowed. Finally, the Environment Protection Act came, and with that, some environmental regulation also came. Environmental impact assessment also started happening. But what we are seeing now is a reversal of all that which had happened. we are seeing gradually that environmental regulation is being dismantled. Despite the fact that we now know that the environmental regulator must be independent of the government. And the reason is, it is the government which normally proposes or allows certain development. The regulator which examines whether this development should be allowed or what are the costs of this kind of environmental costs of this kind of development, costs and consequences of this kind of development, cannot be a person controlled by the very same government which has proposed this development. Has to be independent. And the Supreme Court said that in a judgment many years ago. It's been now 15 years since that judgment where they said that we need to set up an independent environmental regulator in this country. And for 15 years that has not happened, with the result that the government sets up this environmental impact assessment body. And today that body has largely become a rubber stamp of the government. They are not examining. I'll give you a recent example in your vicinity. This Vihinjam port, I don't know how many of you are aware of this Vihinjam port. I have studied the matter in some detail. Now this port, because you have to make what is called a wall, it's a 3.5 kilometer long wall made perpendicular to the coastline in order to protect the ships which are coming in. Now the consequence of construction of this wall is that, and this is something which was stated in several scientific papers, including one authored by a scientist, what's his name? Anyway, some scientist of Kerala who authored several papers on impact of these walls on the beach on both sides. So what happens is, because there is shifting ocean currents, one season they go one way, the other season they come back another way. The wall construction, actually what it does is, it removes the sand from the northern end of the wall and deposits it on the southern end because of the nature of the ocean currents in this region. And therefore, because of the building of this wall which started in 2017 or so, we have been seeing, if you look at satellite pictures of the beaches around here, whether the main beach or the that Kovalam beach or the beaches even beyond that, you can see that on the northern side there is rapid, year after year, there is greater and greater erosion of the beach. The coastline has been coming inwards, and on the other side there is accretion of sand. Now, the same gentleman who had earlier, before this port came, Udale, who had authored several papers saying that the scientific papers saying that the construction of a wall leads to this effect, that on one side there is erosion, on the other side there is accretion of sand. He was now appointed by this government in a committee. When this matter went to court about the impact of this port and the sea wall, the court said, all right, you appoint an expert committee to look into it. When people complained that, look, now you can see that there is huge erosion on the north side of this wall and accretion on the south side. So the court said, appoint a committee. Now the government appointed a committee headed by the same gentleman, Kodale. Now we thought that he would remain consistent with his view that construction of a sea wall has this impact, at least in Kerala, because of the ocean currents. But this gentleman has turned totally around And he says, ki, no, this erosion and accretion is not because of the construction of the wall. It is because of cyclone which came in 2017. It is because of global warming. Absolutely ridiculous things. Cyclone came and went in 2017. How can that cyclone have an effect after that, year after year after year? It's 2018, 2019, 2020, 21, 22, 23, 24. You see the satellite pictures, you see year after year after year, there is more and more erosion. How can the cyclone of 2017 affect this? Then he says global warming. No, global warming will not happen only in Vihinjam or around here. Global warming is happening everywhere. So unfortunately, you see, what happens is when the government appoints these environmental regulators or these so-called experts and so on, they do what the government wants them to do. And that is why we need independent regulators. But there is a larger, deeper, more serious problem with environmental regulation. Now, if you take global warming, see, global warming is happening because of the rise of the levels of carbon dioxide or carbon in the atmosphere. Because in the last 100 years, we have burnt a lot of oil and coal and so on. Oil and coal, which was the year of millions of years of vegetative matter being trapped under the soil and it being converted into coal and oil. This is the product of millions of years. And we have burnt it all out or half of that in the last 100 years. We have consumed millions of years worth of vegetative decayed matter in a matter of 100 years. And the result is that there is so much buildup of carbon in the atmosphere that carbon causes this greenhouse effect and it is causing global warming. Now, every year or almost every year or every other year, there is an international meeting of all the countries to address this problem, and they come up with agreements, Kyoto Protocol, some other agreement, some Rio agreement and so on, in which they decide, all right, these are the targets, we need to reduce carbon emissions to this extent from up this year. By this year, we should have the carbon emissions down to 50% of present levels, then to 25% and so on. But this has been happening for the last 20 years. But we have seen no reduction. We are only seeing every year after year after year still an increase of carbon emissions. Why is this happening? Why are they not being able to comply with their own agreements? The reason is, you see, there are externalities. Unfortunately, there are externalities of development. And these externalities are really global in nature. That means, if I allow gas guzzling vehicles in this country, then the effect of that gas or petrol or diesel being burnt and the carbon being released is not merely being felt by us. By us it is minuscule. It is now spreading globally because this carbon buildup goes global. So, there is, unfortunately, the world is divided into 200 sovereign nations. If the carbon emission and the resultant global warming was restricted to each country, then perhaps that country would have some incentive, some serious incentive to curb their carbon emissions when they see that this global warming is happening. But every country feels that, well, our carbon emissions will go all over us only in a small way, it will affect the others as well. And every country feels that. So no country feels that there is any incentive to curb these carbon emissions because of the externalities of your domestic activity. And that is why I have always felt that either we require a world government which can rigidly enforce. You can't have these 180 sovereign nations each deciding what to do, what not to do. You either have a world government or we need some kind of artificial intelligence. This is just an aside. I wanted to just alert you about the developments that are taking place in artificial intelligence. You see, today, after this Chat GPT-4 was launched, there is a lot of talk about what is called artificial general intelligence and artificial superintelligence, which may be coming soon. Artificial general intelligence means artificial intelligence which has multi-dimensional capability like humans, which can do all kinds of things and do them better than humans can do. Artificial superintelligence is an entity which is is not merely general intelligence, but it is so superior to human intelligence that it has the capability of taking control of the planet from humans. And I believe, my own personal view is that we are rapidly moving towards this artificial general intelligence and artificial superintelligence, and it is going, and these intelligences will be autonomous. They will not be under human control. They will modify their own programs, algorithms, etc., and therefore they will decide what they want to do rather than our deciding what they should do. So either we have a world government or we will have this artificial superintelligence which will eventually take over, take control of the planet, and in my view perhaps be able to deal with this problem by putting and enforcing regulations about use of carbon and so on. So environmental regulation, number one, requires that the regulator be completely independent of the government. And environmental regulation also requires that the decision-making body should be a global body and which should also be able to enforce its decisions. And that is why I say that this problem of carbon emissions is not going to be solved. We have seen it for the last 20 years. It is not being solved, and it will not be solved unless we have a global government. Global governments are needed for other reasons as well. Today, for example, Israel is committing genocide in Gaza. And unfortunately, because of the lack of a global government, despite the International Court of Justice saying that they are committing genocide, we are not being able to stop them because they say that we are a sovereign nation, we will do what we want. And unfortunately, the other country which could have stopped them, the US, it is also going along with them and doing whatever they want to do. So therefore, we need a global government for other reasons as well, but including for environmental regulation and enforcement of those regulations. Now, public interest litigation relating to environment. Lastly, I just wanted to touch on this. So there are certain environmental issues which can be taken to court, and some which the court will say, look, this is now eventually a matter of government policy, executive policy, and we can't substitute our own judgment over the judgment of the elected government. So what can be taken to court, what can't be taken to court? Firstly, I wanted to say that when you file a public interest case, firstly, you have to first think of what are you seeking from the court? What order do you want from the court? Suppose you are want to tackle the problem of corruption. And you say, well, there is a huge problem of corruption in this country, court should pass an order to stop corruption. The court will say, look, we can pass that order, but how will that help? Our passing an order to stop corruption is not going to stop corruption, just as all these agreements about global warming, they are not doing anything. So what do you want us to do specifically, which will stop corruption? If you go to court saying that, all right, you ensure that these anti-corruption agencies, as happened in that Vineet Narayan case or that Hawala case, the anti-corruption agencies which are investigating corruption, like CBI, should be free of government control, because these agencies are investigating the corruption of the government, and therefore there is a conflict of interest. Therefore, unless they are free of government control, they will not be able to investigate high-level corruption of the government. So then the court can say, yes, all right, this is something which we can examine and we can do, which may effectively help in this dealing with this problem of corruption. So therefore, first duty of a public interest lawyer who wants to take a public interest matter to court is to very carefully think what is the order that you want to seek from the court. And then you have to find the legal basis for seeking that order. They will say, all right, you want us to do this, but tell me what is your right? Where does your right come from to seek such an order? So you have to then say, well, I am seeking the enforcement of this particular fundamental right. For example, the Supreme Court has held that Article 21 rights include the right to live a life of dignity, which includes the right to water, food, health, education, basic health, education, and a decent environment, and a corruption-free society. So therefore, you have to say, all right, this prayer arises from this particular right. I am seeking the enforcement of this right, due to which I am asking for this prayer. And then you have to ensure that you have the best possible information on this subject, that you have the best possible understanding of this subject. So you go and find out who are the experts, who are the people who have understood this issue, dealt with this issue. You reach out to them, you try and understand from them as to what needs to be done. For example, say this Wayanad tragedy. Now, if you want to file something, some public interest litigation on the Wayanad, around the Wayanad tragedy, where you want to say, all right, in order to prevent such tragedies in future, ABCD needs to be done by the government. What is that ABCD? For that, you will have to reach out to people like Dr. Kasturi Rangan, who gave that report, or other experts who have studied this issue. What is it? What kind of development which has been allowed, which should not have been allowed in these areas, which is leading to these tragedies? Because if you go to court with a half-baked petition, where you have either not formulated your prayer properly, or not found the correct or a good ground for approaching the court, or not consulted the relevant experts in order to understand this problem properly, then you are doing a great disservice not only to yourself but also to others who may later want to come to court, or who may be wanting to come to court on the same issue, but with proper homework. So you need, as public interest lawyers, you need to do your homework properly. So if you want to go to court on any environmental matter, you have to first decide what is the prayer that you want, What is the basis? Basis is given by the Supreme Court. Ki, all right, having a fair environment is part of Article 21 rights, and you have to consult the best experts. However, still there are certain issues where the court can interfere, certain issues where the court can't interfere. Suppose you go to say, look, this development was allowed, but the environmental consequences of this development have never been studied. Nobody has studied them in the government, and yet this development, which has enormous environmental consequences, has been allowed. So you stop this kind of development till the environmental consequences and the cost benefits have been studied by some body or some authority. In the Narmada Bachao Andolan case, there were of course several issues involved there. There was the issue of displacement, there was the issue of environment because it involved submerging a large amount of forest, etc. And there was this issue of costs and benefits. Now, one of the judges in that case in the early judgment, Justice Bharucha, held that, look, environmental impact studies have not been done. If they have not been done, how can you allow this project, this dam, to go forward without doing the environmental impact studies? So he said that you first do the environmental impact studies and only thereafter you can take this dam forward. But unfortunately, the majority view in that case, two of the other judges held that no, environmental studies can go along with the construction of the dam. To my mind, that was an absurd view, but unfortunately, the majority took that view, that the studies can be done along with the construction. Unless you understand what are the costs and consequences, environmental impacts and consequences, how can you go ahead with the raising of the dam? So, this is one ground on which the court can interfere, that is, to study the cost, benefits, etc. But suppose the government studies the environmental costs and says, look, yes, this does have some environmental cost, but it also has so much benefit because there is so much development taking place. For example, the Silver Line project, this rail line which was proposed for Kerala. Now, I have again studied this project. One of the greatest experts in the railways studied this. Dr. Sridharan also studied this. They all spoke against it, saying that this will cause havoc because you will have to build a new railway line through the ghats, etc. It will cause environmental havoc. But suppose the government comes and says, all right, we have looked at all the environmental consequences, etc. and we still decide that the benefit of having this railway line is worth the environmental cost, then what does the court do? Court can only say, look, you have not studied this, you have not looked at this properly, you have not done this properly, etc. The court can also say that, look, your expert committee report is absurd, like this gentleman who has given the report now on this Vihinjam project. His report is absurd. I mean, he's saying that this is because of cyclone and global warming, etc. Utterly absurd. So the court, sometimes the court says, look, we are not experts, we can't go into all this. But in my view, if the expert report is absurd, it doesn't make any logical sense, then the court can say and should say that this is an absurd report. And you either appoint other experts or we will appoint some independent experts to go into it. So, but if after looking at all the cost benefits, the government still comes to the conclusion that, look, we still want to go ahead with this project because we feel that the development benefits are worth the costs, then in my view, the court can't substitute its own wisdom over the wisdom of the elected government. So then the court will have to throw up its hands and say, look, we are not some people who can substitute our wisdom, even if we feel that this project should not go ahead. But if the government has considered everything and the government feels that it should still go ahead, then they can take it ahead. So those are some of the issues that I just wanted to flag before you. I hope that you have found whatever I have said of some use. Thank you very much.